Good morning, good afternoon, wherever you're joining from. I'm Fred Buret, Blockchain Investigations Manager at Recoveris, and welcome to another session of digital asset recovery around the world. In this webinar series, we go jurisdiction by jurisdiction, speaking with practitioners who deal hands-on with disputes, investigations, and asset recovery cases involving crypto. The goal is simple: understand the local landscape, the types of cases arising, and how recovery actually works in practice. Today's format is 30 minutes discussion, then Q&A. Please drop questions in the chat as we go. And just to note that nothing today is legal or financial advice. This session takes us to Bulgaria, home of one of the most famous crypto lender and currently embracing the new European regulations, MiCA. I'm delighted to be joined by Konstantin Mikov, founder of Mikov Attorneys. Konstantin, welcome. Over to you to introduce yourself and the work your firm does.
Hello, hi Fred. Thank you for the invitation. So I am a Bulgarian lawyer and have specialized in dispute resolution for more than a decade. And so I'm generally doing financial dispute resolution. And of course, now I'm doing also crypto dispute resolution, including the crypto tracing and recovery of crypto following investment scam most of the time. So I have quite a lot of experience into the financial dispute resolution. First, I started with the Forex binary option 10 years ago. It was a really huge amount of financial scam. And right now, nowadays, I think that the crypto scam has become even more widespread than the initial Forex and binary option scams.
Do you see cases where there's a bit of both, or a scam has migrated from Forex to crypto, for example?
I think they have migrated. Yeah, there is a migration, and I think it started 5 years ago, something like that. But the migration is step by step. It's not. It was started. By the way, the first crypto scam, started even before 2020. Okay, but gradually they increased, and gradually the Forex and binary option and CFD scam decreased substantially during the last 5 years.
In the last 5 years, yeah. And they use crypto as a mean of transferring the proceeds, or it's easier to open a wallet, I guess, than a bank account. You don't need any KYC, and then you have more control on the
front. Yes. Initially, it was the case, but there is also now, there is also for the money laundering, but there is also crypto platforms for investing. They say you can invest crypto, you need to buy, etc. And at the end, it is an investment scam. So it is the same like the Forex, CFD, and binary option scam, but they just changed the nature of the service. And now you are investing on the crypto markets. So I think it's the same. They're using, of course, crypto for the money laundering, but the idea is the same: to lure investors and to take their money.
Understood. So it's also the volatility or the get rich quick that is enabled by crypto and attract.
Exactly, the get rich quickly, the leverage. The false marketing promises, etc. So everything that is related to the social engineering marketing that we know from the 2010s onwards about the financial services was transferred and used for the crypto sector. Yeah.
Excellent. I know we're going to touch later on the regulation and the role of this regulation, but just going through our agenda, I would like first if you could give any insight in what type of crypto businesses are active in Bulgaria. I know one crypto lender who is based there from previous cases, not adverse to them, but they are quite famous. But is there any other activity or any insight that you can share on what's happening in Bulgaria in terms of the crypto sector?
Okay, so Bulgaria is famous with maybe you're referring to Nexo, but they are Bulgarian, but actually the structure is outside Bulgaria. In Bulgaria, they have most of the call center or administration, but the legal entity are outside Bulgaria, actually, all over the offshore jurisdiction. So Bulgaria, the landscape is like most of the country into the EU. We have the regime of the VASP, the virtual asset service provider, that are obliged to report in terms of anti-money laundering rules to the competent authority, which is, of course, a very light regime, and it's not a licensing. And so there are a lot of companies doing that. In Bulgaria, you don't need a big infrastructure, and there are a lot of foreign companies, foreign brands, okay, that are registered a VASP in Bulgaria and provide it into the euro, or in Bulgaria, providing such kind of services they consider that they have the right to provide it all over Europe, which is not very clear, but doesn't matter. So this is the landscape, Bulgaria. I think I have a number of 180 currently registered, something like that, into the VASP register, but not all of them are active, of course. Most of them have registered and have a very limited business activity, okay? So a few of them, based on public sources and from the regulated, there are 30, I think, that have currently business activity in Bulgaria, which is worth, let's say, continuing with the new MiCA license regime. So the VASP, and now, yes, the SASP. Now we have the MiCA in Bulgaria, of course. This is EU regulation, and the grandfathering period is end of June. And of course, currently the VASP are trying to obtain the license, and this is something which is quite difficult, by the way, complicating. And actually, there are very few until now that have applied formally for a license. And most of the time, I have clients. They don't expect such kind of administrative, business, etc. Requirements, and it takes time to comply with them. So it is a complex procedure, and you need, of course, to prepare. It takes time, and my experience is that most of the people doing the business right now are not prepared for the licensing in terms of psychology, let's say, and business and capital requirements and business plan, etc., etc.
Interesting. And the retail market or the professional investors are based in Bulgaria. I think this type of framework will give them an indication of which are the services they can use safely and which services they should maybe double check or not use because they're not complying or went through this process. Is it the goal of the regulation, do you think? Is it going to bring a safer space in Bulgaria?
Yes, this is yes, but not only in Bulgaria, because the regulation, this is a European regulation and market. What does it mean? We need to understand that if you have a regulation in France, Germany, you can after that provide in Bulgaria, etc. So now the big players, the important and serious companies, they are trying, for example, to apply into serious, into jurisdiction like France, Germany, and after that provide such kind of services. Okay. In Bulgaria, for now, most of the people into that business, there is only, by the way, one company that has received the SaaS license, but it was an investment firm, and they used the kind of bridge between investment firm regulation and MiCA regulation. Okay, but even if there is one or two regulated in Bulgaria, if any big name, big brand has a regulation to the EU, they will obviously be able to provide to the Bulgarian citizens and the local market, and vice versa. If a company gets a license from Bulgaria, they will be able to reach any EU market, any EU market. So,
okay. So it's a step up for any services who will have this registration or license, and I'm not sure how to call it, license, to access the whole European markets from one jurisdiction by playing in one jurisdiction.
Exactly. And now the battle is to get access to the license in jurisdiction that market themselves as crypto friendly. This is a marketing by the regulators, which is more marketing that, because I'm not sure what does it mean crypto friendly when you have one framework, one set of rules, which is common for all EU jurisdiction. So I'm not sure how the German can, or the French can say they are more crypto friendly than the Bulgarian, Greek, or Romanian, because they need to have the same. The requirements are almost the same. Yeah, and you have the ESMA, the ESMA, the European regulator, who is giving very clear and very detailed, let's say, doctrine, requirements, guidance for everybody, which means that actually, in my opinion, the choice of jurisdiction is a choice that is actually, I would say, there would be no huge differences between the jurisdiction.
Yeah, it's about the rest of the landscape. What would attract them to choose this jurisdiction, not only the regulator or the regulation that they need to comply with.
This is the people, exactly, the people, the management, the employees, the quality of the infrastructure, technical infrastructure, offices, etc. I think these are the main criteria for any kind of crypto of SaaS to choose its own, to choose the jurisdiction. Yeah.
Is there anything more particularly around the protection of customers? For example, what to do when an account is a specific person or business is victim of a phishing scam or a hack, or even in terms of preventing fraud? Do you know what are the steps that these businesses will be required to take in broad terms?
Yeah, in broad terms. First, if it is something happens in Bulgaria, okay, so something happens in Bulgaria, the victim could be in Bulgaria or the crypto service provider based in Bulgaria, and there is a kind of link to Bulgaria. So under the Bulgarian jurisdiction right now, before into the old regime, let's say, you need to ask the criminal authorities to make an investigation. So we are continental law country jurisdiction, which means that you need to rely on the criminal authority to be able to identify the parties involved, to ask the crypto service provided for the IML information, etc., and to cooperate with other jurisdictions, because we know that such kind of scams are always 99% international. And the success of your recovery depends on the quality of the investigation, which everybody understands takes time, it's difficult, and very often unsuccessful.
Yep.
However, now with the new regime, I think that could be a huge, in my opinion, huge improvement for the victims of scam, because it would be far easier to get the information quicker, to get the information from the SASP regarding any kind of transaction. As you know, people know the scope of the activity that is subject to licensing is very large under the MiCA. For example, even the services which are half or almost automated, like the services of exchanging crypto in an automatic way, switching between different ledgers, etc., such kind of technical services right now provided by some famous company outside EU are subject to licensing into the EU, and which means they not only they need to have the IML of the client that are asking such kind of services, but they need to report such kind of services, such kind of transaction. They need to report who asked the transaction, what they did, and who is the beneficiary of such kind of transaction, crypto exchanges transaction between cryptos, to the competent authorities, which means if there is any kind of scam, very easily and quickly, you can get the information. Right now, for example, it's almost impossible. From the experience and technical, from the investigation and technical information I have right now, depending on where such kind of services, but all the time they are made outside Europe, now it's impossible. So you can trace up to a certain level, and after that it's impossible to know who is the beneficiary of such kind of switching between different chain mixing, blah blah, etc. So this is, in my opinion, something that would definitely help the victims of crypto scams in the future.
Yeah, brilliant. There's one question that comes on many of my cases, and it's also one of the potential way of recovering the funds is the responsibility of the exchange that was used by the victim, usually with the fraudsters whispering at their ear that they should, and guiding them through opening the account and exchanging their fiat for crypto before sending it to the fraud. And it's about the responsibility of this exchange, which is likely to be one of the exchange licensed locally or in Europe. And there was a case in the US recently against crypto.com. It was dismissed, I think, by the judge because of some limitations around when more on admin reason more than the case itself. But still, the judge brought some comments around that the exchange was not owed to know that it was a fraud, and I have a kind of different opinion. I feel that they have the responsibility. They are the gateway between the fiat world and the crypto world, and they are the last step where there's a possibility to stop it. And so they are actually, I think some banks here in the UK are asking every time you do a transfer a bit more than usual or anything unusual, you'll get a call, or you have to fill in a kind of a form saying that it is not a fraud. You're not being pushed into investing in a scheme of any kind, that you're doing it under your own will. And I think exchanges with a license in Europe or anywhere where there's a will to protect the user would need to fit with this criteria, with at least asking the question: are you sending it to yourself? Are you sending it? Is someone helping you to transfer these funds? And yeah, is it something that you?
So Yeah, this is something we are doing. So first we are doing that with the fiat money, but here there are two different aspects. First, this is the crypto exchange of the victim. Second, there is the crypto exchange of the fraudster. Okay, so it's important for the victim. Yeah, the crypto exchange is obliged to make a KYC to understand why the victim is buying, etc., etc. But yes, on a case-by-case analysis, the crypto exchange, if it has some kind of red flags, about some red flag, by the way, crypto wallets, because there are such kind of information. They need to inform the victim, etc. So they could be on that way a kind of liability of the crypto exchange. On the other side is the crypto exchange of the fraudster, and usually that's where it's easier to prove that the crypto exchange should know that his client is a fraudster. It's easier, I would say, technically. Okay. But currently, it's very hard to find out the crypto exchange of the fraudster. And most of the time, we know that such crypto exchange are based outside EU. And actually, they don't communicate it. They are offshore. And actually, they are just empty shells. And you can do nothing against them.
Yeah, I know someone commented in the chat, and it's very true, is the receiving exchange of proceeds of frauds may not be aware that the funds that they're receiving are tainted. And this is actually a strategy that we use a lot at Recoveris, is that we try to be involved as soon as possible then as the fraud happens, so that we flag addresses on blockchain analytics firms, but also through different other channels, for informal, informal, to flag addresses holding stolen funds before they are being sent to exchanges, so that it helps inform these exchanges that they should do something about it and liaise back to try to recover this fund for the client. There's no other choice.
Yes, but yeah, sorry. I agree, but the exchange, okay, the crypto exchange of the fraudster, if it is based in EU, let's say, is supposed also to make the AML checks and to ask, what is your business? Why did you get this kind of crypto? What are you doing exactly? And to dig into the business and relationship of his client with the third parties. So yeah. Actually, if it is a crypto in Europe, even now, a VASP, they're supposed to know what their client are doing as a business. And if they ask the right question, it's, in my opinion, quite easy to understand that they are actually, they have an illegal business. It's not so complicated, okay? Yeah. As I said, what is complicated when such kind of exchange is outside EU and
which they are,
actually, yeah. Which they are. Exactly.
And there's also I've seen and analyzed disclosures from many different exchanges, and there's also receiving the funds that we were tracing, proceeds of frauds, and you'd see that the individual on the KYC doesn't have any business, or at least not you can't see it online, and they would have more than 20 million USD going through their account in a space of 6 months, and this itself should raise some flags. At least it would in the normal banking system.
In the normal banking, but not only, because the rules are the same, the IMF rules. In the normal exchange subject to serious exchange subject to the IML, they should report that. They should report that immediately.
Yeah. Immediately. I think I would like to pick up before we have to wrap up. We have 6 minutes left. A bit more about how does it work in terms of you mentioned briefly when you have you're working for a client who fell victim of a scam. What is the usual process with working with law enforcement or the prosecutor? What are the different options, and how does it work in practice?
Yeah, very quickly. So as I said, you need to make first a criminal complaint. A criminal complaint in order first to get information about the people, the identity of the companies or the people that receive the funds, the crypto, let's say, assets, in order to be able to prosecute them through a civil court, etc. So this is the most, let's say, difficult part right now with the crypto assets in order to recover. After that, this is just a recovery, normal litigation recovery against people that are identified as having or owing the crypto assets into a kind of portfolio. You can, of course, make any kind of freezing if the exchange is in Bulgaria. You can freeze crypto accounts. Okay, you can after that recover for crypto accounts if they are based in Bulgaria or Europe, of course. And the procedure, I would say, is quite similar to a procedure which is about money, about a bank account. You want to freeze and recover from a bank account.
That's good. Not reinvent the wheel.
Yes.
Using
it is similar, except that now actually you know the transaction because you can see them, but you don't know who is the beneficiary. On the other side, when you have a bank, you don't know the transaction, but you know the first direct beneficiary because they need to give you information about the bank account, the name, where it is located, etc., the company, etc. So that's now the main difference.
Yeah, you will not know who is controlling the account or the deposit address or the account linked to the deposit address or the private wallet, but you can keep on tracing when it's a private wallet up to whatever service they are doing and the other activity. So do you see like collaborating with the public sector, law enforcement prosecutor in the UK it's very difficult. So I can imagine that maybe in jurisdiction like Bulgaria, they have an understanding of what crypto is and how this investigation work. And is the door open for this kind of discussion, or is it difficult?
Sorry, I come back. Can you hear me?
We can hear you.
Sorry, yeah. There was a technical issue. I'm really sorry, but
Okay.
yeah. So we were left. Could you just repeat where we?
Of course. So I'll start again my question. No problem. So the question was, you mentioned that you work a lot with the public sector and especially prosecutor and law enforcement to initiate a asset recovery. Are they up to speed in terms of capability, and are they open-minded to the different aspects like specific to digital assets, or is it where are they in the learning curve? That's my question.
No, in the learning curve, yeah, in Bulgaria there is a specialized, it's called cybercrime.bg, a specialized institution, and they have quite good experts. So they don't have, I think they understand how it's going on, and they are working in cooperation with the foreign authorities. So I would say that there is quite of good competence, understanding about the crypto transaction, how it's going on technically, etc., etc. Of course, if you can use local private expertise, which could be useful for them, especially for the most technical parts, like the switch between different ledger, etc. So I'm not a specialist, but there are some technical aspects that may be very complicated and could be useful for a private investigation to do a crypto tracing report and to provide it to the competent authority. But technically, the most difficult part after that, when we identify how it's going on the transaction, is to get information, especially when it's outside Europe, and to get information from offshore crypto exchanges that actually do not even reply. This is the information I have from the public prosecutor. They don't even reply. The authority of the given offshore jurisdiction don't even reply, etc. So this is the most difficult cooperation.
Okay. And when they reply, do they share the information with you so you can keep on investigating and pushing the matter forward, or is it on their side and it's delegated?
So it's up to the public prosecutor to decide to share. It depends on the. It's very subjective. It's case by case. Okay. So they can share, have such kind of course, such kind of experience, but it depends. It depends on the really case by case. Yeah. Because you must understand, if you are victim, until the indictment, actually, it is, which is very late into the procedure, and you are victim. Upon the indictment, you can get all the information officially, and indictment, which is the act just before going to court. And then into the court proceedings, you have the right to make your civil claims. This is very late, usually. Before such kind of indictment, it depends. During the ongoing investigation, it is a question of subjective, let's say, appreciation of the public prosecutor to give you information and that you can use into a civil court.
Okay. I know we've gone slightly over time, but I have one more question for you, Konstantin. Is once we have some assets that have been frozen and the government is able to seize these assets, this is where you bring the civil case in these assets so you can recover them.
Exactly.
Okay.
Once we know where are the assets, into which exchange, and we bring the civil court. Exactly.
To bring it back.
Now it is with exchanges, because if it is of course the assets is owned is off exchange, it's very tough to oblige the person to give you the keys. I don't have such kind of experience in Bulgaria.
Yeah, it's
I'm talking about on exchange, which basically is like a bank account. Sorry, it's just a bank account. They are obliged to freeze it, and they're obliged after that to transfer, because the asset, the keys, are owned by the exchange, and it's a kind of account, bank account, which they can and they're obliged to transfer.
Yeah. Oh, okay. But thank you very much, Konstantin. Now, if you have any questions, please drop them in the chat. I'm going to say a few words to wrap up this webinar. So thank you very much to our speaker, Konstantin, for sharing your insights, and everyone who joined us today. I would advise you to keep an eye on the LinkedIn page, our LinkedIn page, for announcement of the next episode. We have planned session with Ukraine on the 27th of March and Singapore on the 1st of April. And we are currently planning upcoming session with law firms based in Dubai, Hong Kong, Spain, Austria, and Brazil. And I'm very excited to continue exploring how digital asset recovery plays out across these different jurisdictions. Thank you for joining us, and we look forward to seeing you at the future session. Thank you, Konstantin.
Thank you, Fred. Goodbye.
Goodbye.